City Institutions for India initiative at the Center for Policy Research in partnership with Omidyar Network and the Property Rights and Research Consortium. A brief introduction about the organizers. Omidyar Network is an investment firm focused on driving empowerment and social impact at scale. PRRC is a network of leading think tanks and research organizations that drive policy action in the field of land and property rights in India. And finally, the land planning and housing vertical of the Sci-Fi initiative aims to deepen the understanding of governance and sector-specific challenges in the field of land, housing, and planning in urban India. Rental housing in India has been predominantly regulated through the rent control laws that were first introduced in the colonial era and continue to be implemented in independent India. These laws aim to safeguard the interests of the tenants by stipulating a ceiling on the rental amount and specifying conditions for eviction of the tenant to prevent landlords from charging exorbitant rents. However, as these laws were evidently skewed in favor of the tenants, they disincentivized house owners from renting out their units. This has not only limited the supply of the rental housing stock, but has also, to an extent, manifested the vacant housing conundrum that the country is witnessing today. Further, as the COVID-19 pandemic has triggered an unprecedented migrant exodus in the country, it has also underscored the destitution of the migrant workers and the lack of housing securities in the cities. This has reinvigorated the need for a policy and regulatory framework that provides them access to safe and affordable rental housing. Recognizing this, the Government of India initiated the affordable rental housing complexes as a sub-scheme under the urban component of the Pradhan Mantri Awas Yojana in 2020. Now, to enable the implementation of the ARHCs and to provide for a much needed regulatory framework that balances the interests of the landlords and the tenants, the Union Cabinet approved the Model Tenancy Act 2021 on the 2nd of June this year that had been in the draft stage for a very long time. In today's policy dialogue, our distinguished speakers and panelists will critically examine the provisions of the Act and discuss its role as an essential tool to provide inclusive rental housing to a large part of the urban population. This dialogue has been structured as two sessions. The first session will highlight the key provisions of the Act and the state-level experiences of its implementation. The second session will be a panel discussion between our esteemed panelists on the implications of this Act for various stakeholders. Before we move on to the opening remarks of the session, I would like to inform you all that this session is being recorded. I request all the audience members to use the Q&A box for your questions to the speakers and the panelists. And now with this, I pass it on to Ms. Shilpa Kumar for opening the session. She's a partner at Omidyar Network India, where she provides overall leadership, including strategy and investments. Prior to this, she worked with the ICICI Bank Group and also served as the MD and CEO of ICICI Securities. Over to you, Ms. Shilpa.
Yeah, thank you, Arushi. It's my pleasure to be here, and we are delighted to co-host this policy dialogue on the Model Tenancy Act 2021 in association with Sci-Fi and PRRC. The reason for our interest in property rights and housing is driven by our view that property and home is important for really driving socioeconomic well-being of every citizen in the country. I think migration has always been a key part of the Indian growth story. As a large section of the country's population moves to cities every year in search of a livelihood, this translates into a large demand for rental housing, and about 1/3 of the urban population resides in rental accommodation in India. However, absence of a good organized rental housing market has meant that almost 75% of such rental housing is provided informally. To our minds, this translates into three significant outcomes. One, it affects low-income workers and their families the most. Second, it has a high impact on the quality of living conditions, as informal housing translates into a lack of access to basic governmental services. And third, the combination of this double vulnerability exposes a large section of the city's working population to a double insecurity. I think COVID put a spotlight on the lack of safe and secure housing as the city saw an exodus of its workforce when it headed back to the security and safety of their homes during the pandemic. I think the gap between supply and demand for rental housing in urban areas has only continued to grow over the years. And even old data like the 2011 census data points out to the big gap between the demand for housing, the fact that 17 to 24% urban population lives in unauthorized housing, even while 12% of urban housing remains vacant. I think Arushi talked a little bit about the paradox, and we are therefore actually, keenly looking at in terms of how this can actually bridge the gap, how it can provide a regulatory framework for affordable rental housing in the country. I know there are continued, concerns, some apprehensions over the Act's efficiency. And this policy dialogue is really important to look at three things: improving access to the rental housing market to achieve housing for all, bridging the gap between ages and current stock of vacant housing, and thirdly, increasing formal private investment in the rental housing market, especially for affordable housing. I am, for one, looking keenly forward to the deliberations today. And with that, Arushi, I will hand it back to you. Thank you.
Thank you, Ms. Shilpa, for your presence as well as your opening remarks for this session. I would like to inform all the panelists and the attendees that we have just heard from Mr. Ashwini Kumar's office, who was supposed to deliver the keynote address for this session. But unfortunately, due to a work exigency, he will not be able to join us for this session. So we have requested our colleague, Ms. Isha Khurana, to step in to make a presentation on the overview and highlights of the Model Tenancy Act. Isha here is a researcher at the Senior Research Associate at the Center for Policy Research in the Sci-Fi Initiative. Prior to joining CPR, she worked as an assistant professor for law at various private institutions. Over to you, Isha.
Thank you so much. Thank you, Arushi, for such a warm welcome. I'll just share my screen with the legislation once. I hope my screen is visible to everyone.
Yeah.
Thank you. So there was an urgent need for the new regulatory framework when it comes to the rental housing. And primarily the need arose because of these four reasons. One of them was to balance the interest of landlords and tenants. Then we realized that there was a housing shortage, as even Ms. Shilpa was pointing out right now, because of increased demand and increased mobility. Thereafter, there simultaneously also we saw that it was to encourage the growth of the rental market to maintain a healthy mix of housing stock and thereby a balanced price to the rent ratio. We also saw that there was a housing paradox, that we have 1.1 crore vacant housing lying, and also we have a shortage of 1.9 crore housing units right now. So to tackle all of this, and it's been a while that we have been deliberating about the need for model tenancy law, just primarily to ensure that there's increased private participation in the rental market. There is, as Ms. Shilpa again was pointing out in her opening remarks, that we can balance the interest of landlords and tenants. There is the housing paradox is tackled in a pretty well manner. Because of which this year, the Union Cabinet gave approval to the Model Tenancy Act. Now, Model Tenancy Act 2021 has primarily three objectives. One of them is to establish a rent authority to regulate the renting premises. It is also coupled with the fact that we need to protect the interest of the landlords and tenant. We also need to provide speedy adjudication mechanism for the resolution of disputes. Moving on, we have systematically highlighted the key features of the Model Tenancy Act into 4 categories. That is tenancy agreement, rights and duties of landlord and tenant, statutory recognition to the concept of property managers, and 3-tier adjudication system of the tenancy disputes. When it comes to a tenancy agreement, so the Model Tenancy Act very categorically states that all the rent agreements, rent, lease, tenancy agreements, by whatever name that we use in a common parlance, they mandatory need to be in a written form, and they should be registered, not registered, sorry, but they should be intimated to the rent authority within a period of 2 months from being entered into one. It also, the MTA envisions a situation where a digital platform is set up at every state level, preferably in a vernacular language, wherein all the documents are submitted, and they provide a schedule, they provide a form in Schedule 1, which will actually contain all the details of the tenancy agreement. They also mandate that the Aadhaar number also needs to be mentioned when you're uploading all the documents in the rental on the online portal. Now the catch here is that the Aadhaar number being mandated has raised a lot of concerns around the corner. We also have a process that kind of incentivizes the landlord and tenant to enter into formal rent agreement. The entire idea of having a dedicated adjudication system when it comes to rental disputes is something that will incentivize the landlord and tenants to enter into formal rent agreements. Moving on, the fact that they also specify the MTA has a lot of provisions which we have seen for a while now, like the period of tenancy, which can be mutually agreed by the parties. There is restriction on subletting, and it can only happen through a supplementary written agreement, which also needs to be informed to the rent authority. We have the rights and obligations of landlord and tenant have been captured quite precisely in the legislation right now. So I have broadly mentioned the same on the slide right now, but there is a schedule 2, which has enlisted all of them very precisely. So in situations the landlord and tenant wants to go ahead with those kind of obligation, they can just go ahead and use schedule 2 as a draft and go ahead with the rights and obligations of it. One of the very important features of MTA is that now it is trying to limit the security deposit to 2 months when it comes to residential properties and 6 months when it comes to commercial properties. So this kind of variation we have seen throughout the country, wherein the security deposits have been varying in different states. So this is quite a nice step forward in this regard. The concept of property managers has been for the first time been legally recognized in the MTA. So they say that a person or a legal entity, including a rental agent authorized by the landlord, will be uh, will be considered to be the property manager, and the property manager will act like an agent of the landlord, and subsequently they can collect rent, do essential repairs, go ahead with the inspection. They can also help in the resolution of disputes between tenants and landlord. The important part is that the rent authority that we're actually being established out here, that will have a power to remove the property manager or impose a cost on him in situations he's contravening his duties. We also envision a 3-tier adjudication system. Now, this is one of the basic objectives of the MTA, that we need to establish a 3-tier adjudication system in the state, in each state, one being rent authority, thereafter rent court, and then rent tribunal. So rent authority would be the person who will be heading it would be a person not below the rank of a deputy collector. So the intimation of the tenancy agreement, the revision of the rent, the deposit of the rent, the property managers working, all of that would be overseen by the rent authority. In situations we are not happy with an order or a ruling of the rent authority, we can go ahead and appeal to the rent court within a period of 30 days. Also, all the execution of the orders, even the orders of the rent authority, would be done by the rent court. An appeal from rent court, we can go ahead in the rent tribunal. So these are the key highlights of the MTA 2021. Subsequently, actually not even subsequently, but even prior to MTA 2021 coming into picture, Tamil Nadu came out with its own legislation that is called as Tamil Nadu Regulation of Rights and Responsibility of Landlords and Tenants Act 2017. Now, this was enforced in 2019, but it's a very much vibrantly active legislation in the state of Tamil Nadu. They have based their legislation on the 1516 draft of the MTA that was there in circulation at that point of time. So there are a few variations that we can see in comparison to the MTA 2021 right now. Like, for example, this Tamil Nadu legislation, it talks about intimation of the prior tenancy agreement. So even if the agreement has happened before, so that also needs to be intimated to the rent authority. Subsequently, it also talks about the fact that the rent security deposit should be 3 times the monthly rent. So now we see twice the monthly rent for security deposit, but earlier it was 3 times. Moving on, it also has a few other variations which are primarily procedural in nature, like constitution of rent codes, tribunals, refund, compensation. But these are key variations primarily based out of the earlier drafts of the MTA that was in circulation. In 2019, Tamil Nadu also came out with the respective rules for the legislation. So we would love to hear from Mr. Jayaprakash going on how Tamil Nadu, what is the implementation experience in Tamil Nadu with respect to this. Moving on, very recently, I think I'm stuck on the slide. Just give me a second, please.
Isha, in case there is an issue, I can share my screen for you.
Yeah, I think I got it. Just give me a minute. Yeah. Sorry for the technical error. So also very recently, Uttar Pradesh came out with an ordinance, first in January, and now it has also come up with the second ordinance in April. That's called as Uttar Pradesh Regulation of Urban Premises Tenancy Ordinance. Now, this also has a few variations. Like, for example, it says any tenancy agreement which is for period less than 12 months need not be intimated to the rent authority. That is quite a different move, or that's quite a key variation when it comes to MTA 2021. It also talks about the fact that there's a two-tier adjudication system that they're actually visualizing in Uttar Pradesh. That is rent authority and rent tribunal. So they do not envision, or they do not think of constituting a rent court out there in UP. They also say that for an appeal to happen from a rent authority to a rent tribunal, pre-deposit of 50% of the entire amount payable has to be done. They also have envisioned a situation of negotiated settlement of disputes, which is akin to a mediation in the legal scenario. So these are the key variations in the UP ordinance that has come up right now. Thank you so much. And over to Arushi, please.
Thanks, Isha, for this insightful and informative presentation. I now invite Mr. Jayaprakash Padmanabhan to share his experiences from the state of Tamil Nadu in adopting the Model Tenancy Act in the form of the Tamil Nadu Tenancy Law 2017. Mr. Padmanabhan is a partner at Fox Mandal and Associates and has over 20 years of legal experience in real estate related litigation. He has also been appointed as an external legal consultant to Tamil Nadu's Real Estate and Regulatory Authority, the Housing Board, and the Housing and Urban Development Department. Over to you, Mr. Padmanabhan.
Thank you. Thanks, Arushi. And good afternoon, everyone. Let me jump into the subject with a caveat. Whatever views I express in this discussion or my personal views, I'm not either representing or voicing out the government's decision or government's view on these aspects, and I'm also not representing anything from the firm. So all the views are of my personal opinions. So this is one legislation which touches upon everybody's life. So home is something everyone need, and we all know what is the demand on the rental stocking, which needs to be addressed. So when we initially started the discussion, 2017 was the enactment of Tamil Nadu tenancy law, the new one. The prevailing law was an Tamil Nadu Building and Lease Control Act. So the mere title to the act itself gives us a preview of what it is. So that is a controlling legislation where it controls the environment surrounding the leasing stock. So there is an fair rent fixation procedure for eviction also, even if the term of the lease is expired. Eviction also, the lessor can actually evict only on specific equitable grounds. So only if he justifies certain equitable grounds, he can evict the tenants. So this enactment, the model code that was circulated for the states to actually follow guidance is of the year 2015-16. They wanted to bring a balance the way the leasing industry operates. Basing that, Tamil Nadu has enacted the tenancy law, repealing the old act in 2017, but it was not given effect to immediately. There were deliberations going on even after the notification of the act. There were deliberations going on. And in 2019, February 22nd, February 2019, rules has been notified for this new tenancy law, and it came into effect. To simply put, simpliciter, what this enactment says is your agreement is supreme. Your agreement will prevail because this is a commercial contract where one person owns the property, where he's invested and he is actually constructed, and he is expecting a reasonable return from that investment what he has made. So it primarily says that your agreement is supreme. Whatever terms you agree under the contract, that should prevail. So the governance or control, statutory control, which was available earlier in the Lease and Rent Control Act, has been taken out. Following the model code, this law has been legislated. In Tamil Nadu, this law has been actually given effect to retrospectively. They've given a comfortable timeline of almost 575 days for the leases which were prevailing on at the time of implementation of the act, that is commencement of the act in February 2019. They've given a comfortable timeline of 575 days for them to actually reduce this into a written contract and submit it before the rent authority. So submission before the rent authority is not a registration per se, it is an submission of information. That also the thought process, what as a lawyer I would understand or I would actually think is, since speedy adjudication of litigation has to happen, you need to have a summary proceedings wherein an authentication is required for that contract, where it has been already authenticated by an agency. So for that reason, I think a regulator has been appointed, and we need to actually submit the information with the regulatory authority. All the processes surrounding this new law has been made very, very simple. It's a simplified process. It's only an online application, and the total number of data which needs to be submitted is around some 10 to 15 credentials is what totally you need to submit. That all the credentials are in fact from and out of the lease agreement which has been executed. So this is a completely online driven process. There is no stamp duty, there is no registration fee independently for this process. It's 100 rupees service fee you need to actually pay, and all e-Seva centers have this facility of actually helping out the public in submitting this information. So this act, though it has been given retrospective effect, the experience of what we are actually facing for the last 2 years, or in my personal experience, when I actually take the data, the kind of traction what this legislation should have actually gained, that has not happened till date. I think the registration what has happened with the rent authority on the entire state would be around some 6,000 and odd registrations have been done, and there are certain applications pending. To analyze why this kind of actually response is there, because this is a welfare legislation, the landlords who are actually facing difficulties in evicting the tenant or handling the litigation should have actually come forward and registered themselves before the authority. What I could actually say is, one is there is general awareness about this legislation is very less in the society. The second one is the perception surrounding providing any kind of information to a statutory authority. Public is not very comfortable in actually providing the details to a statutory authority. That is one reason. And another third important reason is this act doesn't have any pecuniary penalty if you don't register. So the act, Tamil Nadu Act says that if you don't register the tenancy agreement, what will happen is that agreement will not be admissible in evidence. So there is no penal provision where it says that there will be a penalty or there will be some kind of actually punishment. That is not the case. So that also actually puts the public at a very casual approach to this legislation, though it is a compulsory mandatory registration is required. Section 4 talks about a mandatory registration. The effect of non-registration is of no severe implication. So that also adds on to this kind of lack of response. And of course, any legislation, when you have a regulatory framework, when you implement with processes and procedures, creating the infrastructure, those kind of latches are there, but that is not the main reason, I would say, in my experience. The system is well performing. The online applications you'll be able to submit. The response from the public as a whole for this enactment is not something what we could actually say in this 2 years of experience. This legislation, what it wanted to achieve, I'm very doubtful in my personal view that they have achieved that. So this is our experience in Tamil Nadu so far. Probably I'll be happy to actually get involved in the panel discussions and see where exactly we may need to focus to bring this welfare legislation more into the forte. So with this, I'll close my opening remarks.
Thank you, Mr. Padmanabhan, for your comments and insights from Tamil Nadu. I now hand it over to Mr. Bhagato Dasgupta, a senior fellow at CPR, to open the floor for a panel discussion. Thanks.
Thank you very much for Ms. Kumar, Mr. Padmanabhan, and Ms. Khurana and Arushi for this first session. We have a very interesting mix in this panel discussion. We look forward to learning a lot from it. I would like to take a couple of minutes to introduce all the panelists together, and then I'll request one panelist to come at a time. I mean, the panelists consists of researchers, practitioners, and business people. And lawyers, of course. Well, to start off with, we have Shaloni Patranabis, who currently is a PhD candidate at the London School of Economics, but has done an interesting paper in a last at the think tank CSEP in the last year. So she will talk a bit to one of the main motivations that the introductory note to the MTA kind of refers to, which is this vacant housing issue. We have Ms. Suruchi Suri, who's partner with Suri and Company, and that has worked in the High Court for more than 15 years. We then also have Mr. K.P. Krishnan, who's currently IEPF chair and professor at NCAER, but has had an illustrious career as leading various ministries, and in our interest also has been principal secretary, urban development in the past in Karnataka. Mr. Rahul Pandit, who is a secretary at the Rental Housing Association of India, is expected to join us very soon. They have put together this rental housing association in the recent past, and I guess they're looking at more commercial properties for co-living, which has become a big area. We look forward to hearing from him. And we are delighted to have with us Mr. Arun Kumar Mishra, from former Secretary, Ministry of Housing, under whose leadership much of this rental, the rental task force was set up, which did the early drafting, which helped with the early drafting of what today is the MTA. He was also part of creating the early drafts of the RERA also. And I've had the personal privilege of working with him for 2 years. So as a brief introduction to the panelists, the idea is that we will spend 5 to 10 minutes maximum on opening remarks. We'll come back to the panelists if there are questions and for clarifications. Mr. Krishnan, Dr. Krishnan has requested that he needs to leave early, but maybe, so you still have some time. So
not so early.
We can go on with your opening remarks, Shaloni.
Thank you so much, Shubhagata. The recent work that we've done, that I've done with Dr. Sahil Gandhi and Dr. Richard Green at the Center for Social and Economic Progress, is basically a wide analysis of why India has so many vacant houses. To put this into perspective, around 11.1 million houses were vacant in India according to the census of 2011. Interestingly, the census of 2011 is the last count of vacant houses that we have. We're not even counting that particular problem. In as much, this forms around 12.4% of the urban residential stock. And so we started asking, why are landlords leaving these houses empty? And therefore, the question is about an intentional vacancy, where the landlord finds it beneficial to just leave the house vacant instead of trying to access the extra income they could have had by renting that house out. And what we find is extremely interesting, especially considering the Model Tenancy Act as it has come at this moment. So the idea is that the income that the landlord has is a risk-adjusted income. When the landlord puts out a house for rent, they're adjusting certain risks with it. And the primary sources of these risks, the first one that we found was the complexity and stringency of rent control acts. And the primary one there was the restrictions put on revising the rents of any housing that has been let out. In as much, we calculate that if these rent revision terms would be liberalized as the Model Tenancy Act proposes, whereas Mr. Padmanabhan said that it's all about the agreement is paramount, we would actually add 2.8 to 3.1 percentage point houses back into the market. The second issue that the MTA tackles in its present form is the issue of contract enforcement. we find that the lack of state capacity, and here we measure judges, the lack of state capacity for contract enforcement is another big contributor towards vacant houses. Districts which had fewer judges per thousand urban population had much higher vacancy rates as compared to districts that had more judges. So considering that the Model Tenancy Act actually sets up a separate entity to litigate on, to solve litigations of rentals, is an interesting proposition, but the caveat here is that these cannot be the same judges. There needs to be an actual increase in the number of people handling these litigations to ensure that that state capacity constraint is actually loosened. Another interesting thing we do is we look at a placebo effect, because a lot of conversation about vacant housing in India has not necessarily been about rent control. It has been about people buying houses and then leaving them empty for speculative purposes. And here's where we need to start thinking about the risk-adjusted incomes of landlords again. In India, in most cities, if you put your money into gold, you would get a better return than buying a house and renting it out. The risk-adjusted returns of Indian houses on rent are that low. Therefore, it's extremely important that any iteration of the MTA that is implemented effectively tackles these issues that cause the risk-adjusted incomes that landlords gain to be improved. They need to have confidence in the system that is adjudicating their rentals. They need to have confidence in that that when they rent out their houses, it's for their benefit, or else we are struggling with covering for 18.8 million housing shortage that is 18 million strong in 2012 with one hand tied behind our back, because 12.4% of our houses are simply not on the market. Those are my opening parts. Thank you so much, Shubhagata.
Thank you. So you do think that the MTA will help clear out some of these bottlenecks?
It is my hope. It is my hope.
Okay. Right. Then maybe we come to you, Dr. Krishnan, first before going on to Ms. Suri. Dr. Krishnan, from your hat, from trying to recollect your hat as Secretary Urban Development, it'll be interesting to hear from you a bit about the state capacity issues that Shalini just raised, as to whether simply putting the burden on the administrative quasi-judicial system has led to results in the past, or how you look at it from that perspective, and from the research, your current research perspective, to what, given that rental housing is still a young community in India, there isn't as much research happening on it. What thoughts come to your mind?
Thank you so much, Shubhagato, and thank you, Arushi and Sean Lee, for that background material. It's very good to be here in this panel. It's good to see a lot of old friends, senior colleagues. My greetings to all of them. Let me use my 6-7 minutes to respond to the key questions outlined in the note, and I hope to answer some of the questions that you raised, Shubhagato. I essentially have broadly 7 sets of points, but let that not worry you. I'll make them quickly. Point 1 is related to process. I wish Dinesh or Ashwini of the ministry was here. The formal website as well as the formal documentation available in the public domain does not tell us what is the problem being addressed. What were the competing solutions that were examined? Why was this chosen? What are the risks, rewards, and what will it actually succeed for this Model Tenancy Act to succeed? We are all guessing. I have access to these people. I went and spoke to them because, I mean, completely independently of your panel, I was just curious to know, what is this new animal? Is this the rent control legislation coming back in suit and boot or in some other new form? So we know that there have been 3 previous attempts: 1992 model legislation, 2011 model legislation, 2015 model legislation. What have we learned from those? How many states adopted them? Why did states not adopt them? So my first is a broad process-related set of questions to which only the public authorities can give us an answer. Second is the factual background, and we all know this. Rental housing saw a 30% decline in a 30-year period ending 2011. This is census 2011. We know the data. We also know from census that 12% of India's housing stock is vacant. And NSSO 2012 tells us that 71% of the households did not have a written contract. Shilpaji alluded to this. So clearly, the second broad point, an obvious point, India is reluctant to put houses out on rent. This is very evident. There is clear evidence, and India's reluctancy to put houses on rent seems to be increasing over time. 3, we know the history of rent control laws. Entry 18, list 2, state subject, trying to protect tenants from high rent, from eviction on sort of unjustified grounds. Most of us who, for instance, in my state of Karnataka, this used to be a complete racket. And all that you had to do was to find the right rent controller, game the system, occupy a house, and occupy it thereafter for life. So what is the actual evidence of rent control legislation? There is anecdotal evidence that I've seen, but in Ministry of Urban Development's scheme after scheme, since this was a condition, delegislating the rent control legislation was a condition, we assume rent control legislations failed. 4th point, Sean Lee made this right now. Sahil and the CSEP work on this is excellent, which explains the urban housing vacancy. 3 clear reasons that I see, again alluded to in my predecessor's address: low yield on property, market distortions caused by rent control legislation, and informality. Now, is MTA coming anywhere near any of them, and can it? I have doubts. What are MTA features? This has been covered already in the presentation. I don't want to repeat it. The point that stands out about MTA is that this is agreement based. Now, the question that I had for Mr. Padmanabhan, which I quickly sent out in the chat box, was if we are going back to agreement, essentially we are repealing the Rent Control Act, which is a special legislation, and there is a general legislation called the Indian Contracts Act, which should simply work. Why do we need another special legislation to deal with what appears to be an agreement question? Enforcement of an agreement is what is being emphasized. And if that is indeed the case, the answer is make sure that the Indian Contracts Act is well implemented. Comments on MTA. My 6th point, essentially 2 broad sets of comments. The district administration now seems to be emerging as India's answer to all problems. If you see, and this is not an accident or a one time, the agricultural legislations, the famous ones on which farmers are doing dharna, the land lease related legislations, and now the MTA, all of them seem to go back to the district administration. And with the permission of my very senior colleague and well-wisher, Mr. Mishra, I can take a little sort of be slightly lighthearted. This is the UP Carter view of the world. We have to solve India's problems through the district magistrate. Now, if you do it more seriously, very serious overload on the district administration already. There is an enormous amount of work, for instance, done by Devesh Kapoor, which now brings out serious data on what is the time allocation by SDMs or sub-collectors or assistant collectors in terms of the kind of things they do. It's mind-boggling. There is simply no time left for anything. Two, we know the enormous amount of corruption in these organizations. Three, judicial determination by executive authorities is, I think, a dangerous way forward. So I have serious problems with this MTA's approach. The second issue I have with the MTA, a minor one apparently, it mandates Aadhaar as one of the requirements, and which clearly flies in the face of Puttaswamy. So you've drafted a legislation in 2001 with so much thought that you are not aware of what the Supreme Court has told you less than 1 year ago. So this legislation will probably be struck down even before it takes off on this ground. Last point, and very basic fundamental points, what is the market failure? Inability to let people do agreements and enforce them, as Shawnli correctly said, is state failure. This is not market failure. Can MTA solve this? It cannot. I don't think the Ministry of Urban Development can solve India's larger judicial non-governance problem. Any special legislation, you can put any amount of time limits, but we know what is happening to check bouncing cases. They have time limits. I know of 20 legislations which have time limits. None of them is working. Two, I think a much larger question on which ideally, Shubhagato, somebody like you has to begin to think, namely, how does one engender state level reforms? This is, I think, a serious federal question in India today. Power sector, housing sector, agriculture, education, health. These are all sectors where unless we do reforms, India's sort of distribution of growth is not going to happen sensibly. Government of India does not have enough instruments. So how does one think about reform of state level subjects at the federal level? Last point, I think it's time we stopped doing public policy in complete empirical vacuum. I don't see any data, I don't see any arguments which persuades me that MTA is the way forward. And I have some thoughts on your specific questions on how do we improve the data, etc. But I've exceeded my limit by 40 seconds. I'll stop here, wait for another opportunity to come back.
Sure. Thank you very much for those opening comments. I mean, so all the critical issues that you mentioned, I guess going for, means in the current world, from moving from let's say statism to let's say neoliberalization in the depths of urban policy is a multifaceted, slow-moving process. I guess this means both the AHRC and the MTA in that sense kind of it can be seen both as a climax of some processes that were in place, but maybe also a new further push towards some a context where there is a centralization that seems to be overriding strengthening local institutions. But it'll be wonderful to catch up on you more on it. I will now move to Ms. Suruchi Suri from her legal perspective on some of these points that Dr. Krishnan mentioned.
Evening to my esteemed panelists and everybody who's attending. Since Ms. Isha has already gone over the provisions of the Act, I wouldn't get into the nitty-gritties. Mr. Krishnan, of course, has pointed out very big macro issues. So I'll keep to Mr. Das Gupta's very helpful pointers, and try and answer whichever issues he the legal aspects that he wanted me to cover. Very quickly, I totally agree with my co-speakers when they say that the Act doesn't seem to know what it seems to, the purpose it seems to be wanting to meet. It is exactly my view as well, because though the purpose of the Act has been spelled out to be to establish a rent authority, to regulate renting, to protect interests of landlords and tenants, and to provide speedy adjudication for resolution of disputes, the larger issue of why all this was required in the first place has just not been spelled out. Any legislation should have a very legitimate goal that it seems to or should be working towards, and that it seeks to be making at the end of the day. So though it ticks all the three boxes, unfortunately I don't see a macro picture there, and I was hoping that in this event today I would learn from my other co-panelists, which is already an exercise that is happening. But I wonder if the need was for revenue loss on stamp duty, etc., for them to insist on tenancy agreements being registered. I think Mr. Mishra, Mr. Krishnan may be better placed to explain why the need to come up with this legislation without even touching upon these basic aspects, whether it was leading to loss in state. I was speaking to the real estate team partner at Suri and Company, and he had a very interesting perspective on this. I was asking him, on ground, where registrations are required, and if his team sees any problem in its working. And while discussing the Act, he pointed out, he said, you must note that in 2011 the situation was very different. We were suffering from 2008 global economic slowdown, etc. So rentals and housing issue on that date cannot be addressed adequately by an Act which is coming up now in 2021. In 2021, we are facing a different issue perhaps of housing, where executives in NCR region have vacated their homes because everybody seems to be working from home. So in the sense that this is an outdated legislation, with due respect, I do agree to the criticism that has come up of the Act. And I totally agree that it is also micromanaging a lot of aspects. In the courts, we always see, and even the courts are supposed to respect intention of the parties. And unfortunately, this Act seems to micromanage even access to the property to carry out structural changes, repair, etc. These are issues that are best left to the tenant and the landlord to regulate. A model legislation is not supposed to get into the nitty-gritties of agreements. And considering larger issues of perhaps not preventing discrimination of women, LGBTs, etc., has not been addressed in the legislation, I really don't understand why they wanted to get into the smaller aspects of who is responsible for repairs, etc. But privacy issues here are very, very real. But before I get into the privacy issues, Mr. Dasgupta had helpfully asked, from our past experience, whether we have seen in other sectors how mandatory registration works. And we have seen in the legal field that the grassroots, the grassroots system seems to be in place. We can pay our municipal bills online. We can pay our Delhi Jal Board, BSES, NDMC, property tax. All of this, the payments can be made online. The registrations seem to be in place more or less. And municipal tax collection is online. It seems that slabs are different for self-acquired and rental properties. So all that seems to be in place on the ground anyway. My guess is possibly that the purpose of this Act was because states are somehow losing some kind of revenue, but I will leave it to Mr. Mishra and Mr. Krishnan perhaps to address whether this anticipation of mine is correct or not. Secondly, on whether it would be easier if the civil court route is replaced by a dedicated 3-tier rent authority and tribunal quasi-judicial process if the CPC has to be followed. My specific view on this is tribunalization has always been criticized. It has never effectively worked, and courts have not bettered their functioning because certain kinds of important cases were taken away from them. Even with due respect, the NCLTs, etc., are not meeting their timelines, as has been pointed out earlier some time ago. Timelines are not being met by any court or any authority. So it's not like the system becomes more efficient by making a tribunal. And here, effectively, the appointees itself might be, doubtful. I totally agree where, SDMs, etc., are completely overburdened, and I agree with Mr. Krishnan's view that making them responsible for these nitty-gritties and the legal judicial aspect of it may not necessarily be the wisest thing to do. But we have this we have the act now, and we will have to deal with the consequences. I do agree with Mr. Krishnan that I also, after seeing the act, strongly reckon that this act would be struck down before it even comes into play, because very clearly there are privacy law issues here. Aadhaar is definitely an issue, since the Puttaswamy judgment had made it very clear that if you require an Aadhaar linking, you have to show a relation with expenditure on a subsidy, benefit, or a service incurred from the consolidated fund of India. Now, if that is if we are unable to show that, then there is just no excuse why they would require Aadhaar linking. And with due respect, registering a tenancy doesn't obviously carry any benefit or service for which the CFI would have any logical connection. So this may not, this part will definitely face an issue. But I see other privacy concerns, and I've been speaking to data experts on this. They don't understand the need for creating this repository of information and updating all the information in vernacular, etc. I think very basic questions, especially in today's very crucial, in the crucial aspect of privacy, which is coming up in every aspect of our lives now, has completely been missed in this act. Why is this information required? Who has access to this information? Who is, why do they need it, more importantly? If all this is not clear, then I think this is something which would be addressed by the data protection bill whenever it is thoroughly taken care of. Because we don't understand which officials will be able to access it, whether it's an open access of sorts, something like our Vahan, etc., where we find out, we can find out our challans, we can find out the status of the registration of a vehicle, etc. I just need to put in a number and the entire data is available to anybody who can access it. So very, very valid privacy concerns. The issue of consent, because I'm guessing clearly photographs, phone numbers, email, financial details, etc. will be asked for and put up in vernacular language for whatever reason. We don't know whether these would be deleted, whether this information would be shared by the government, maybe with insurance agencies, with financial institutions, etc. And data protection with respect doesn't actually come about only by a Supreme Court case law. It will come across only by a statute. And unless we have those statutes in place, this is a troublesome act. And I think if I have I have covered all the aspects, particularly relating to privacy and micromanagement, that this act seems to cover. And I look forward to any questions that may come towards the end of the session.
Thank you very much, Ms. Suri. I would have to invite Professor Mr. Mishra into this discussion. We are very keen to hear from you both on the thinking around the need for the MTA at that time when it was initiated, the committee around this. We are keen to also hear about the district collector approach. I do see that it's very popular in all government programs under this regime. But if you can throw light on both of these, at least from my side, I'm very keen to hear from you.
Thank you, Subhagata. Thank you. I will try to respond to some of the concerns raised by KP and Suruchi and others. Let me bring in this caveat. Even though we started it in 2011 and the draft that was made in 2011, honestly, I personally feel that when you bring it in 2020, it could have been improved. It definitely could have been improved. We never expected the same draft that was circulated in 2011 will be adopted in 2020-21. Rightfully, Suriji has made many questions about the privacy issues and the relevance issues. Having said that, let me try to give you a little background of why this draft was made. I'm in a position of some authority to say that because I was Secretary Housing and Urban Poverty Alleviation, but in 2011 to 2014. That is the time when we were coming out with the new policies. What is now known as RERA Act was already passed by the Parliament at that time, but again brought back in 2015, but it was final. We had initiated many programs under the Housing for All program, which was renamed subsequently. And one of the activities that we were also trying to do was this rent control legislation. And we were keenly aware at that time that the rent control legislation was also under the purview of the Ministry of Urban Development at that time, which was a separate ministry. When we drafted this, we had 3-4 basic information available to us. One, of course, was the 2011 census, which basically said that more than 11 million households are lying empty. Then it also said that 30% of the people in India live on rental housing. Incidentally, when we conducted surveys in the slum areas also, the percentage of people living on rental housing in the slums were also almost like 29 to 30%. So it's common whether it is a rich person or a poor person or a slum dweller. The people who lived in the rents were about 30%. And the third, of course, is the migration now has been suddenly highlighted as a big issue. Even at that particular time was a very, very important issue. I had personally gone and seen the way the laborers lived in Chandigarh and other places, the way in which they were put into a particular corner. So it was a very difficult issue. That is the fact. We commissioned a study to find out the housing needs of the country. And they came out with a report in 2012, which very clearly said that Professor Gundu report that 19 million households, new houses need to be constructed. And mind you, out of this 19 million, more than 90% of the house requirement was in the poorer section, not in the middle income group, not in the upper income group. It was basically for the people. So let's face it, so far till that time, the rent control was rent control. And everyone was interested in continuing with that particular control system because it gave a lot of powers to what KP mentioned about to the bureaucracy. When you talk about Delhi, it was the Ministry of Urban Development. When you talk about the state governments, because most of the properties are in Bombay or in Lucknow or in Calcutta, they were all controlled by the state governments and by the ministries. The control was important. And because of control being very important and control being extremely favorable, one, either to the state bureaucracy or to the tenant, because the Control Act was so designed that the landlord was at a disadvantage. That's why, even though there is a need for 30% of the people of the country, the rental housing scheme was getting bad to worse. So 4 things we wanted to do. One is move away from the control mechanism to an agreement mechanism. And secondly, the concept of standard rents should be completely dispensed with. I would have personally preferred to bring in a clause which said that, like in Tamil Nadu, they said after 600 days, all the old acts and all the agreements will cease to exist, will have to be renegotiated. But that was at that time not in the purview of the ministry. That is number one. The second important point was we had to bring a balance between the landlord and the tenant so that no one becomes very important or less important. When Suruchi mentioned about why should these details be listed out, the details are required to be listed out because in real life, where when you go to a place, say Lajpat Nagar or Malviya Nagar, you find that the people who are not the kind of friction that you find between the landlord and the renter, because the landlord is not able to raise the rent and the renter is not able to vacate it. So all kinds of things, the housing stock becomes completely debilitated, denuded. That was the second point, to bring a balance between landlord and tenancy. Third, of course, is simplify adjudication. Fine, I agree that the SDMs, the ADM, the district magistrate were very, very overworked, but at least they can conduct summary proceedings, which is a little less elaborate than judicial proceedings. So that was the second best option. And whether you want to keep a 3-tier system like the Act proposed, or you want to do a 2-tier system like UP government tried to do, it was considered to be much simpler than following a judicial system. That was number one. And number two was, it was more by an exception. You go to a rent authority or a rent court or a rent tribunal only when there is a dispute. And we presume 99.9% of the cases, the dispute will not be there. And that's how the whole system was to be designed. So the exceptional cases where the dispute is to be there, it has to go there. And fourth, an important point, and we brought in at that particular time, and the property manager concept. You see, in India, when you are living in a housing society, your housing welfare association becomes your property manager. They manage everything. They kind of take care of everything. But think of a labor colony. I think of a housing stock where the students go and live. Who manages them? There is no one to manage them. And if we legalize this concept of a property manager and make it a part of the system, and if there is a builder who wants to set up, say, 100 small one-room apartments and give it at rent at 4,000 rupees or 5,000 rupees a month, and there is a property manager who can manage those 100 rents, this is a system available all over the world. But in India, we have not given a legal status to that. Now, when you say that we introduced, I distinctly remember, and Subhagato left in 2014, he may not know. In 2014, 2013 and 14, I had personally sanctioned many rental housing programs under the Rajiv Awas Yojana in many states, and I have actually gone and started one in Raipur. So even at that time, we had made it mandatory that rental housing will become a part of our housing stock. That was the reason. That is the reason why it was decided to do accordingly. And how does it promote? How does it promote private investment? The one way of promoting private investment, of course, is make it simple, so that there is an agreement between the property manager or a builder or a promoter with the person who is, suppose 1 million laborers come and stay in a particular place, they need small apartment, give them small apartments, enter into an agreement, manage it properly, and you get a return. Go to Chandigarh. Chandigarh, most of the housing stock that you have, at that time they were paying 8,000 rupees a month as rent. And they were all being managed very well. Ownership was not given. Under our government programs, we give ownership. Ownership is crucial. I totally agree with you. Ownership is crucial. Where it is possible, give ownership. But if the ownership cannot be given, and you cannot just let it so, the rent system should have to be strengthened. And why? What is the purpose of registration? Why was it done? Honestly, we were drafting RERA and we were drafting this simultaneously, so we adopted the RERA pattern. Housing is a state subject. RERA was brought in not to control housing, but to control the transaction that takes place in the housing market. RERA comes into the picture only when a builder goes out to sell a house. Before that, RERA has no role because Government of India has no role in the housing market. Only the transaction part that they will do. Same thing we thought, only the information part. The information, if there is an information, at least it gives protection to the poor person. Okay, there is a valid document, recorded document with a third person where it is in safe custody. And in case I am put into problem, I can say that, okay, this was my document. Go to a Bombay chawl. 40% of the people in Bombay live in this area. Do they have any kind of documents ever? No document that's completely at the mercy of the so-called property manager. So I know these have limitations, but these were the first little steps that were required to be taken. And why not? Why keep this? Why not follow the Indian Contract Act? We have 3-4 lawyers here. I always thought that this act, rather following the established act, if you do all these things in a summary manner, it might be a little faster. Having that, so this is the kind of the background that. Okay, the question is, will it promote this particular policy promote rental housing? Yes. One other thing that could have been done here is, which we did in RERA at that time, we created a separate chapter in giving the promotional role to the regulatory authority. Regulators should not be regulators. Regulators should also be the promoters of that particular system, particular sector. So the same thing can be done here. For instance, how do I create rental housing stock? Unless I promote builders and promoters. The other thing that was also done at that time was we tried to earmark 15% of the FAR, purely for social housing. But now it's difficult because at that time the real estate sector was in the ascendancy. Everyone thought that the sky is the limit. Everyone thought that taking out 15% of the FSI for the poor people is going to be feasible. All of them agreed. Now it may not be the case, but that was one of the ways in which housing stock was supposed to be augmented. So if you take this particular policy or this particular act or this particular guide in isolation, maybe it may not lead you to much improvement. But if you put all of them together, maybe this will. But having said this, I'm again repeating that this can be considered only as a first step. And I was very happy to see two things in Tamil Nadu and UP. UP brought in two important legislations to make it more amenable. Below 12 months, it has become a common practice now. So they excluded it. And in Tamil Nadu, I think UP also excluded Aadhaar. They're not making it compulsory, Aadhaar. So when there is a model, the state governments have the capacity to improve on it and build on it. This is basically a model act, is basically to bring this issue into focus and this is not an end in itself. This is supposed to be, a fillip. And, Mr. Jayaprakash, it takes time. Look at RERA. RERA was officially introduced in 2015, but you've been talking about it from 2011. Even today, there are states, I'm told, I think Silpaji will be able to better tell me. I think even Bengal, even today, after 7 years, Bengal has not still adopted RERA. I'm not sure. I'm completely out of touch with that system. But it takes time. So this model, this particular act, I know it can be improved. Definitely it can be improved. But at least this is the first step. So the next steps now, of course, will be to engage with the state governments, discuss with them, or create forums in which this thing, because let's face it, if 30% of our population are going to live in rental housing, and pandemic or no pandemic, you are shifting your office to the residence, doesn't mean that you still need a residence. You don't need an office, but you need a residence. So this is going to be an important part, and 30% of the people are going to stay there, and particularly looking at the income levels and looking at the kind of returns that we get. So we have to create a situation in which this really gets promoted. I tried to explain some of the things, but I said I'm very happy. Sorry, Swagata, I took a little longer. I think I took some time from all the others, but I thought I'll just make things a little clear to start with. Yeah.
So thank you very much. So that intervention was very useful, sir. Means Mr. Gautam Chatterjee is also raising his hand. So we'll just come back to you. We also have Mr. Rahul Pandit here. Mr. Pandit, we are is from the business sector. Means he works with the co-living space. Has started a number of startups, and co-living is seen as a big entry point into middle-class rental housing, given that the structure of rental housing requirements in the formal economy at least has been changing in the recent past with increased after the housing finance revolution in India. Lots of home ownership was made younger, but it seems to be going back to a more stable level over the last decade. Mr. Pandit, 5-7 minutes to give us your institution, your association's perspective on the MTA. So we'll come back to you, Mr. Mishra, at the end again. There are a few questions here. Mr. Pandit, over to you.
Mr. Dasgupta, thank you very much. I've been keenly listening to everybody and some very, very relevant pointers that I will try and address. And also I was very impressed hearing Mr. Mishra when he said that, when he gave an implementation perspective, because he's been in the thick of things. And a very pertinent point he made that this is not an end in itself, but it's a first step towards engagement. And the big opportunity is that 30% of India needs rental housing. And when I heard Ms. Suri, so she was right in saying, how do we define the purpose and the privacy concerns? And Mr. Krishnan, I've never met him earlier, but I felt that, he's been to the woods and back, because he could rapidly illustrate the challenges, which got me thinking. And Ms. Patranabis very rightly said that, hey, what's the entire risk-adjusted returns model? If I was to look at the total stock in the perspective, it is to say, who are we creating this rental housing for? The big demographic actually is India's migrant labor. Then the opportunity is, what are we doing about our blue collar workers and also white collar workers? And then how do we handle student housing? How do we take care of senior living? How do we take care of assisted living or migrant urban couples? And a very big population that shamefully we have ignored, of which, as per the last census, we had over 21 million people, is people with special needs. So Model Tenancy Act to me is just a small tool. The other two implementation mechanisms is the PMAY and the ARHC. Now, if we were to take a 10,000 feet view, to me, housing is the biggest stake that citizens actually have in the prosperity of their country. So if India needs to move up its Maslow, and if we need to really achieve Atmanirbhar Bharat, then the citizens of India need the guarantee of respectable housing. And while we speak of creating housing for all, the solution doesn't have to be a capex solution, because, hey, we can better utilize our GDP elsewhere. And the opportunity with a very big migrant workforce, whether it be, the migrant labor or the blue collar or the white collar, or specific target population, which may be, let's say, senior living, assisted living, people with needs, is actually not just a pure, stock, it's stock with services. And the big issue is, hey, if there is no viable financial model, then it should not become just a societal project, which is only driven by charity. Because what I have seen is the moment you say this is social and charity, and if there is no commensurate return, it will not flourish. And we can see what's happened in the Nordic countries, the example of Germany, how they have actually used housing not only as a tool for social integration, but also uplifting. And if you look at, their total environmental standards, courtesy the intervention by the government, whether it is saying, how much water is being used to solar, they've actually used rental and social housing as a transformative state tool. And if you see closer to India, one economy I admired, and I've, spent some time working and studying there, is if you see Singapore close to us, 1960, they established a housing board, courtesy which today 80% of Singapore's population is today housed in very high quality, cheerful, and value appreciating assets. So when we are creating solutions for the society, they can't be appendages. Like Mr. Misra was saying, what's happening in the chawls in Bombay. I am in Bombay, you go out and you say, hey, what is this diversity? You have skyscrapers and you have chawls. Are you not subconsciously promoting social disharmony? And the interesting thing is the ruling People's Action Party in Singapore, what many people don't know, that their big election plank, whenever, always to their constituents, is that if you select our people, your housing will be great quality. It will be maintained to great quality. And as you know, they've never, lost a general election. And I would actually be very happy, that if our politicians too and our country moves to a level where instead of, figuring out on divisive items, political parties are promoting great quality housing. Now, if we have to address this, let's look at the key stakeholders. To me, there are three key stakeholders. First is the government and the citizens, second, for whom it is intended, and third is the developers. So we have an urgent need actually of creating a housing development board. And I think because housing and real estate is so much of a state subject, there is the need for creating a Parliament Standing Committee on Housing so that it's directed as an item of federal policy. And over time, this actually becomes a concurrent subject. Otherwise, India will fail. If its citizens do not have respectable shelter on their heads, how will they hold their heads high? On the citizen side, one big tool we have seen that's been rightly done is the implementation of ESI. So similarly, there is an opportunity to create an EHI, Employees Housing Insurance, which could also be tax deductible for the employers. And I heard Ms. Suri's concerns on Aadhaar or could be Jan Dhan mechanisms and all of that. So the mechanism could be sorted out, but benefits have to go to the right people. And if I'm looking at the Germany model or even the Singapore model, the model could be both tenancy and also long-term leasing akin to ownership. And the leasing could be 40, 60, 90 years because the embedded real estate is an appreciating asset. And it's a great opportunity to also get sovereigns and pension funds in. So for example, long-term leasing could be treated akin to ownership for that period. And if you are creating such stock in tier 1, it could be 40 years. If it's tier 2, it could be 60 years. If it's tier 2, 3, could be 90 years. And then the opportunity is one, you create subsidized and also full value for people who want to pay that. Like what's happening in Germany and other Nordic countries, because the quality is so cheerful and nice. And this is not an appendage, you are not creating a slum cluster, because the moment you do it, one is urban planning becomes defunct. And second is, as cities urbanize, this agglomeration has to be centrally. Otherwise, we'll have to keep on creating social infrastructure at multiple places. Will you get schools, colleges, and all that? And then you can say that people can buy or have those rights for their duration. And these could also be inheritance rights. And like even Singapore and other places, they have restrictions to say, you have to be staying there for 5 years or 10 years. Now, when we see on the developer side, a big impetus item could be that all capex which is getting in there could be zero GST. So it obviates first the problem of transferring, anything up, and when the government sends it down, there is transmission loss on both sides. The other is that if you look at our current NBC and other state restrictions, they are very obdurate. So there is a a big opportunity to refresh that. Example, even today, if I see, housing in many places where you are doing it in that asset class or others, there is demand for parking. And funnily, in today's Uber generation and for this talk, nobody is going to have cars. And when you create these restrictions, there are multiple. At least 12 to 15% is just efficiency loss and space lost and capital increase in the project because of this. And the most critical is, what is the viable financial model? As Ms. Patra Nabis had asked, a great model is to effectively look at a PropCo-OpCo approach, where the government, where all these assets are in a PropCo and the government or sovereigns are in there. So what's their advantage? First, they are assured of an appreciating asset. Second, because rent is appreciating, it's effectively an annuity product. And thirdly, because you are not selling it out, you are either renting or giving it long-term lease, the asset is still sitting on the books of the state. And to ensure that the urban planning is right, it has to be zoned by the right asset class. Otherwise, tomorrow when commercial goes up, people will start saying, hey, should I flip this into commercial because I'll get 8 or 9%? Or if you are hung up on cash, you will say, should I just make it resi and sell it? So that's what needs to happen. So if we do all of this, my view is that this is a sector which could be made very desirable. So if you are migrant labor and you need great productivity, it doesn't mean that you are a citizen of the state. If I look at everybody on this panel here, I think we are all very privileged and blessed. At least I feel I am blessed. I had the fortune of being born in a good family. I am that minority in India which today speaks English. But what if, I was not born in that family? I was born into the family of a laborer. Should my country not take care of me? So how do you create stuff which is desirable, which meets the right architectural standards, livability standards, and it has to appeal to people across the income spectrum. So when I studied growth in Germany, for example, their stock, which is supposed to be rental low income, even though the spaces are tight, urban couples are today very happy moving into those places. So as India develops, we have over 5 dozen cities, with the population to go to mini metros. This could be very, very transformational. So that's my thought. And as Mr. Misra said, this should be actually an ongoing dialogue and forums. So I hope that with these kind of initiatives, there is sufficient intellectual capital that we are able to create for the act and for the housing sector.
Thanks, Mr. Pandit. But one takeaway I do take from you all is that the MTA alone is not going to create a rush of private investment into the sector. That message was also quite clear from what you mentioned. We are delighted also that Mr. Gautam Chatterjee has joined us. Mr. Chatterjee, a few comments, questions. We have another 20 minutes to go, so let's make this more interesting.
Thanks, Subhagato. I had a query to my former boss, Misra sir, under whom I have worked in the housing sector. As he mentioned that the discussion in the Ministry, Government of India, on RERA and on this Model Tenancy Act, all these were happening concurrently. I was just wondering, when we talk about trying to burden the present district administration setup with the deputy collectors and all, rather than doing that, if we have now created a quasi-judicial setup under RERA and RERA authorities with digital platform in 90% of the cases in the country, the exception of West Bengal notwithstanding, all other states have come up with robust digital platform and they're implementing the RERA for only ownership housing. If we now talk about the affordable rental housing complex, which should also take shape in near future, where a lot of housing under the rental affordable category will come up, and the model tenancy where these agreements will have to be registered. And then why couldn't we think of one regulator for the sector and empower the existing RERA authorities to take care of not only the ownership housing, which they are doing now, but also monitoring and seeing the affordable rental housing complex coming up in a proper manner, and also the Model Tenancy Act. Your comments on that, Mr. Sir?
Bhagata, do I have a permission?
Yeah, sure, sir, if you want to go right now, or we can take a few more questions and come back.
I think Gautam has raised a very important question. So,
sure, sir.
Gautam, I'll try to explain it. When we drafted RERA and we created this authority, there is only just one authority for the entire state. And you remember that where we wanted to put the tribunals at the Government of India level, at the central level, but the Ministry of Finance did not agree to that. They wanted the tribunals to be in the state level only, which is a very good thing, and we accepted it. So for one full state, we created one RERA, and we allowed the states which are big in size to have more than one benches of RERA in various places. And it was very clear that the number of housing stock that was being introduced per year is much smaller than the number of houses that is likely to go on rent. That actually goes on rent on a daily basis. For instance, supposing I can talk about at that time, the number of new housing stock that was being created was less than 1 million per year. In fact, in the government sector, which Mr. Rahul Pandit talked about, it was just about 200,000 housing units per year. Whereas rental stock is much, much, much bigger. So that was the thought that maybe, but I'm not holding that it should be only with the ADMs and DMs. And you have more experience. You have been in the field and you are looking after RERA. And if you think that RERA can handle it, or there is a particular section in RERA which says that you can appoint a dispute resolution officer. The state government can always designate this one dispute resolution officer rental in every district. It can be done. Because it's a part of your promotional job. So it can be done, and Gautam, and I've been depending on people, some very bright, smart people, very progressive looking officers, states which can take it up. It can be done. But the reason why we did not put both of them on this was that very simple. One state, one authority. It's very difficult, and even at that time, we didn't know how it is going to shape up. Now, in hindsight, we know how it is shaped up.
Thank you. Yeah, thank you, sir. We have a few questions that I will open up for the panel in general. So they are there are questions around the issue that migration is also very geographically specific, and so is rental. Variations in the extent of rental housing in districts. For example, Bangalore and some Mumbai districts, there are even 1 million renters, while in different districts, there are even less. There's not such an account. So how does one imagine this difference, and whether even at the state level there's a wide variety? So is single-handed approach to this kind of a problem something that we need to rethink? Another is about given that in the COVID context, and where it's very evident from past data too that much of the rental is in undocumented verbal contracts, and they are not written up. This move towards what would be the benefits to the consumers, or the renter and the owner, so to say, to list themselves? Would there be adequate incentives to do that? Another is around whether the MTA will ever actually reach slum dwellers. In slum rental housing, how might this play out? There are issues about whether means even in informal settlements, let's say urban villages, where informal markets are in play, converting them into this formal structure of rental housing, what might it take? And then about the rental yields itself, what will it take to get rental yields somewhere closer to something that owners might see as to be lesser risky. And I think what we'll do is go around with to all the panelists and come back to you, sir, Mr. Mishra, to with your closing comments. I would like maybe Mr. Pandit, if you want to take any of these first. We have around 2-3 minutes for your intervention.
Mr. Dasgupta, if you tell me a specific one, then I'll respond.
Yeah, why don't you try and address the yield issue? Means what kind of yields are bringing in private investment into the rental space? We do know that a couple of builders have promised some rental housing efforts post the announcement, just around the time of the announcement. Do you see that the yields in these kinds of entities will be better than in the private market, so to say, the one-on-one market of 3 to 5% across locations?
Okay, sure. See, you have to actually marry two things. One is the purpose and the demographic. If I could plot it on the x-axis, I'm just doing this. And on the y, then you say what kind of returns. So for example, broadly, if I could say that, hey, one aspect is, let's say, a government intervention, where you are saying, I am happy as long as I am getting, if I'm the government, LIBOR plus 1 or 2, because that's my effective borrowing cost. But the impact is that the social benefits are going to everybody else. The second may be pensions or sovereigns, who may be saying risk adjusted, and if they are especially putting in dollar, which anyway appreciates 4.5% every year. So for a full cycle, let me look at 10 to 12% at least yield on cost. The third is then going to be more the private equity type, which is shorter term, which may be, let's say, 14 to 15 yield on cost. And typically, depending on what horizon people are looking at, this may go from, a low of, let's say, 23, 24 on IRR to a high of 28, 30 on IRR. Now, how does one bridge it? At an overall level, one is to say, are you zoning this asset class as such? Second is, as I alluded to, are you creating effectively a PropCo-OpCo structure? Because then OpCo is more cash producing short term and PropCo is long term. How do you do that? And third is, from an efficiency perspective, typically if you can create, as an example, creating 1 million square feet is always better than creating 10,000 square feet. And that always allows you to create communities which are better and more engendered with facilities, and over time the stock appreciates. Now this was an X and Y plot. If I could make it a 3-dimensional, then I will also plot the segments in there. As I said, for example, are you looking at the migrant urban labor, which I think is a big crying need for India today. Productivity here comes later. First is what's happening to their health and livelihood. What is the country's response to this? Because if we don't see, one is we are handling rental housing as a housing issue. To me, the bigger issue is actually a societal issue, that if we do not handle it right, the cost of not doing it, can lead to vociferous tendencies in the country. That's number one. Second is, what are the other segments? For example, how do you take care of blue collar housing? So if you are saying that, hey, I am going to now be creating some place, let's say in Sri City or Sri Perambuttur or Chakan, but hey, if you don't have the right facilities and the social environment, how do you expect people to go in? And the lesson from China is that since the 90s, when they have created this, they have created the total infrastructure in there. So I don't think we have to reinvent the wheel. If you have to look at the development model, I think Germany and Nordic countries have done well. If you look at how it is driven at a federal level, Singapore has done well. I agree, it's a much smaller city state, but we have to achieve the right balance of policy from a federal housing board and then execution at the ground level. Then that's the district administration. Separately, how do you get the right kind of stock for white collar housing? If we are saying today that India's Bangalore is the answer to Silicon Valley, and if you want our people to be delivering, first world solutions, but if you go to Bangalore, and I've been to many of these places, I can tell you, if you went on an empty stomach and you said, let me first go to the kitchen and then eat, 9 out of 10 places you will say, let me be hungry and not eat. So if we are not going to give our citizens the right quality, what right do we have as a country to expect them to deliver good quality? When we similarly student housing, I've been looking at IITs, I've been speaking to IIT Delhi. If you go to IIT Delhi, the stock which was there for students is the same when it was in the 70s. Space which was created for 4 people are staying there, and it's in disarray. So I'm saying, is it that IITs deliver great standards? Because besides academic rigor, we are putting our kids to stuff which is like doing enforced tapasya for them. So you cannot have an IIT beat a Harvard if kids don't have the right facilities. Among friends and family, I have people who have kids with special abilities. And I told you the last census said 21 million. And it's a social stigma in India. Not too many people even speak of it. Their worry is what happens to their progeny after they are gone. Similarly, senior living. How does society carry on those values if our seniors, who have so much of wisdom and intellectual capability inside, they're unable to give it because they don't have the right living community? Or assisted living. If we have the right kind of assisted living, interestingly, we drop the burden on India's healthcare. So while today's discussion may have been more, empty and rental housing, as Mr. Misra was saying, it is just an engagement platform to engender further dialogue, because we cannot be looking at one act or one document and saying stuff will change. The reason I said we need a standing committee in the parliament on housing is because I think we lost, even if I compare to Singapore, we are 50 years behind. I think with all of this intellect and these inputs, it's critical that there be a draft paper which addresses problems, solutions, and then it is put forth rapidly. We cannot be, a democracy, which does so much and stuff is lost out in debate.
Sure. No, it's a very interesting approach, Mr. Pandit. I should put in a plug here and request my colleague to put out last year we did 4 webinars on rental housing in which we had 20 countries make presentations. And it's very interesting to see how stable some of these sectors are in the rest of the world. Means the rules are so consistent. They're planned over 50 years in South Korea. There are models of concessions up to 50 years in South Korea. There are housing vouchers on the other side. So there are a whole set of instruments that means I guess the government should be more carefully looking at. Yeah, as you said, today's discussion is on the MTA. So let me move to the lawyers on the panel. Mr. Jayaprakash, would you have any closing comments at your end? And then Ms. Suri?
Yes. I'm not batting here for MTA. Definitely not the case. But if you ask me whether the tenancy law needs a reform on this subject, definitely it needs a reform. The earlier one, the Rent Control Act, is definitely skewed towards the tenants, and it is a control legislation that has to go out because a lot of abuse has happened in the last 3 to 4 decades. It has been exploited to the maximum possible. So that if we need to give the confidence of the property owners, first of all, I have one interesting observation in this MTA itself. Why we still actually have the connotation of a feudal landlord and tenant nomenclature itself. That itself is very interesting for me to actually see. Why are we still actually calling landlord? And because landlord is the term which is used in the rent control regulation, where there was a feudal system available, and landlord and downtrodden people who doesn't have the capacity to bargain or negotiate their ask. That was the premise on which the rent control regulation was there. Today, the situation has gone. If I invest on a property, I take loan and invest. So I expect some kind of return from there, and I need that kind of ecosystem where I'm confident, where my law protects my interest. So from that perspective, I think, yes, a special legislation in the form of MTA is required. Whether we have actually gone overboard in collecting the information, that is something the policy makers has to decide. What is the thought process behind collecting information? For example, interestingly, if you see, there is a threshold of up to 1 year lease is not required to be registered. Anyways, under the Registration Act, over and above 1 year lease is registered with the sub-registrar. You already have the repository of that kind of data are already available with you. So these are some interesting questions and thought processes where we could actually consider as a matter of how to implement an effective adjudication methodology and a strong law which would balance the rights and obligations of the tenants to a tenancy agreement. There is no two ways about it. Yes, we need a robust environment to protect both parties' interests. So this would be my final comments.
Thank you so much. Ms. Suri?
I think what I would say is I totally agree with Mr. Mishra that this was intended to be a start. But, it's easier to pick holes in something which is then ready in front of you, because you can see it from the nitty-gritty point of view of how is this, why, when, how, what is the purpose, etc. But these are still, goals which we must try and answer at all times, because if it's not going to serve a larger purpose, and I see, after the various stakeholders who are speaking here today, we are completely oblivious to this very real problem of Malviya Nagar and Sarojini Nagar, and how people are living and how the Pagdi system works, and, migrant workers moving out. I think we look at it very simplistically from the point of view of, I may be paying 1 lakh a rent, but, somebody else may be paying 3,000 rupees rent, etc. So the disparity in our country is vast. And perhaps, of course, this being a state subject, legislation was required so that states could then devise something around their own, whatever would be possible for them, etc. It's a long way to go. But other than the privacy issues, I still feel, with due respect, I know it's very difficult to bring an enactment in place, but all these things should actually have been sorted out when this was a bill. At the stage of it being a bill is when, these issues could have been brought up. Now, after the act is already there, with the cabinet's blessings, etc., with due respect, we are having an academic discussion.
Thank you. Thank you.
I'll respond later. Yeah.
Yeah, sir, I'll just come to you. I'll just ask Shaloni whether she has made up her mind after 2 hours of deliberations on this, whether the MTA will work for her or not.
Thank you, Shubhagata. In terms of whether it will work or not, as I said, it's a hope that it will remove the impediments. I believe that that's one way of looking at the Model Tenancy Act. While it's an act and it does a bunch of things, as Mr. Mishra told us, what it does essentially at its core, beyond collecting a ton of data, which is a completely different policy perspective. If you look at the amount of data that governments collect from us these days, it's huge, right? And that's a policy perspective that needs to be taken and debated. But what the MTA does do is that it frees the hands of the state when it comes to a certain section of people who rent their houses. Now, I've been monitoring the Q&A for a while now, and there's a concern that the MTA does not look at informal housing, or it does not look at the poorest of the poor. With all due respect, the poorest of the poor are not going to be able to be housed in houses that were under erstwhile rent control. The talk about rent control, we're not looking at the poorest of the poor, we're looking at the lower middle, upper middle classes, and the white collar migrants who do migrate and therefore require housing. The problem here is that rent control, as it existed, the legacy of rent control made the housing market so complex that a vast amount of state capacity at this moment is now just tied up into litigating these things. And on top of that, that means that whatever falls through the cracks of this rental housing market then needs to be taken care of by PMAY. It needs to be taken care of by affordable housing. It needs to be taken care of by AHRC. By improving and making sure that the distortions in the rental housing market are smoothed out, by taking initiatives like the MTA and bringing it in, and with the states actually looking at the MTA and saying that, hey, for example, Tamil Nadu's example where they brought it in retrospectively, that is extremely appreciable, because that is, it's a known factor. The only country in the world before this which has completely abolished rent control is Egypt. They did it in 1995, but it wasn't retrospective. Vacant housing did not go down there. So that these variations in state laws, as states look at the MTA and bring it to fruition, will happen. And then once one has the sense that, okay, the rental market is a little manageable, then one can look at vacant housing taxes. You push more and more housing into the market. You provide rental vouchers. You enable more people to actually rent the houses. The poorest of the poor will always need public housing in India. It is smart to ensure that the number of people who need that public housing is reduced as much as possible.
Thanks so much. Thanks so much, Shanal. Sir, back to you, Mr. Mishra. If you could also address this issue about casual workers, slum dwellers and menial work, and the migration of, issues around that in your closing.
So I think I'll try to respond. I'm turning out to be kind of government spokesman, which I'm not. So just to clarify, this is a model tenancy act. This is just a model. It can be changed and it should be changed. I've made it very, very clear that the act as it is requires tremendous improvement, and both by way of privacy concerns and also by way of content, number one. And number two is Saloni. The whole idea is to address the issue of the poorest of the poor. How do we do it? Ultimately, they are the people who require guidance and support at every step. Supposing, for instance, a young person like you, or the four of you are young here, you come out with a model, a draft, which you go and circulate in the slums of Bombay. And somehow you're able to convince the slum lord that, okay, this is going to be in his interest. It's going to be a tremendous help. The problem in slums, particularly in Bombay and any other places, there the possession is not always consistent with the ownership of that particular property. I might be running a house which houses 25 people, 25 families for the last 40 years, and ultimately that ownership is with some other person, maybe with Rahul Panditji, and I am operating it. So there is a contradiction there, but the idea of handling the rental issues in slums, of course, is at least in those cases where there is no disagreement between the ownership and the management, or where there is an agreement between the owner and the manager, theoretical manager, then this property manager concept can be brought in. For instance, you are talking about the migrant workers. I agree. It's confined into various places, mostly in Punjab, Delhi, Bangalore, Surat, Pune, Chandigarh, that kind of places. Builders should come up. The biggest challenge, of course, is what Rahul ji is expecting and what Saloni has proven. The average return is 3%. If you are thinking of getting a return which is upwards of 12% on your investment, which is akin to 18% in investment, it is going to be a big challenge. How do you bridge that gap of 15% expectation? You spoke a lot about social housing. All these countries like Denmark, Sweden, and European countries, to a certain extent, England, all the social housing stock built came up after the Second World War. By 1950-55, I think most of the houses, by 60 at least, most of this housing was already there in place. Singapore, of course, it has been a continuous process. Subhagata has information about 20 other countries, you can share it. In India, our primary problem now is, for some reason, the land price have gone up tremendously in the last 10 years. Disproportionately. The very piece of land which used to sell at 1 lakh rupees an acre is now selling at 1 crore an acre. There's no correlation. Why it happened, no one knows. I worked in the sector for a long time. I really can't understand. Why should a 500 square yard plot in Vasant Bihar cost you 15 crore rupees? It doesn't make any sense. Why should someone pay 5 crore rupees for a 300 square yard plot in a good sector in Noida? Because the cost of land has gone up, suddenly the returns have become very, very unviable. The construction cost has not gone up. So how do you make sure that a promoter gets a proper return? Two ways. One, of course, is bring down the cost of housing, give tax relief, give benefits, and then, of course, if you're giving it a long-term lease, then give inter-subsidy, or at least make sure that there's some kind of a return. Supposing on your assessment, the rent comes to say 8,000 rupees a month, whereas my slum dweller is able to pay only 4,000 rupees a month. Maybe the government could come up and say that, okay, the rest 4,000 I will come. We have to think of innovative solutions. Other than that, business as usual will not touch the problem. What has happened? Subhagata knows, when we decided who is the economically weaker section, we decided this is the income criteria. And we said that this is the square footage area that is required. The moment you bring it up and say that, okay, any house which costs you 20 lakh rupees and all, 20 to 40 is economically weak, we are excluding 75% of the population. 75% of the population cannot afford 20 lakh rupees house. The whole purpose of the scheme gets vitiated. So it can be done, but what is important, Rahulji, is, and what is very crucial is, one really needs to engage and find out what are the ways in which it can be done. Wholesale capital subsidy, ownership of the state, out of question. No state government can do it and cannot sustain it. We have to promote developers, the private sector, in such a manner, come out with blended finance, come out with innovative financing mechanisms, so that it makes it feasible. But yes, it's work in progress. So one thing that all of us agreeable is work in progress, and we really need to build on the information available with Subhagata and his team to come out with maybe a better option. But at least it has started. So if we have people like Gautam here, Gautamji is a very big name in Maharashtra. He is one person who can make a difference in a state like Maharashtra. Similarly, if you're able to identify 3, 4, 5 people and engage with them and say, okay, will you please kindly look into this? Maybe things will happen. Sorry, Swagata.
No, thank you very much. I thoroughly enjoyed this from my end itself, but I have Shalmoli Haldar here, whose prodding we put this together. So I will leave her to thank everyone and any other closing remarks. Shalmoli,
Thank you so much, Shubhagata, for putting this together. I think it's an area of big interest for us, given that we work across the spectrum on land and housing and improving the economic leverage that can be possible through the land and housing needs of Indians.
in this space, I think Model Tenancy Act, the fact that it is right now an act and will get implemented in different states, be that Gujarat or Karnataka, already that has put them in implementation, and other states will hopefully soon follow suit. We think this is a great opportunity to sort of bring in such interesting conversations and have policymakers and experts debate these issues. So with that, really wanted to thank everybody for their time and for for such an enriching discussion today. We really hope this is the start of a great conversation. And please don't hesitate to reach out to us, either at Omidyar Network or to CPR Sci-Fi team, if you want to take this conversation forward.
Thank you, Shalmuli. Thank you so much. Thank you, Mr. Mishra. Thank you, Mr. Pandit. Thank you, Ms. Suri. Thank you, Mr. Padmanabhan. Thank you, Shalmuli. So, I think we'll keep this conversation going. Last year, also we had these 4 biggish events. So, I look forward to your support and engaging with you all in further debates around how rental housing evolves in India. Whether there is a need for a policy at the national or state level, which is wider and more incorporative of both the legal side, but also the financial instruments that can be brought into the sector alongside it. Thank you very much. We'll close for today. It was a